During an interview with JW, an authority in securities law, the possibility of an appeal by the U.S. SEC of the court's decision on XRP was discussed by Stuart Alderode, chief legal officer of Ripple. Despite the possibility of an appeal, Alderode remains hopeful that XRP's status as a non-security would remain intact, according to him. He argued that Judge Analisa Torres' ruling that secondary XRP sales are not securities is now precedent, regardless of whether the SEC decides to appeal. Earlier this month, Judge Torres issued a final verdict in the Ripple lawsuit, awarding the San Francisco-based corporation $125 million. Despite the heavy fine, Ripple is portraying the ruling as a victory, particularly as it rejected the SEC's broader attempt to classify XRP as a security in all cases. This is the thing. Even though the results are contradictory, Ripple has taken this as a win, especially considering their drawn-out legal battle with the SEC and Morgan. According to a prominent XRP community member and lawyer who chimed in on the conversation, Stuart Alderode is skeptical that the SEC is acting responsibly in the cryptocurrency market. While Alderode maintained that a reasonable person would not file an appeal, the SEC's recent moves give the impression that this is not the case. Although an appeal wouldn't surprise him, he still thinks the odds of a reversal in the Second Circuit are fewer than 10%, which is in line with what Alderode suggested. Not even in the case of an appeal, XRP and its secondary market transactions are not securities, according to Morgan's public reassurance. An expert in securities law enforcement and a former CC employee, Mark Fagel, deserves special mention. Participate in the discussion, he made it clear that the SEC doesn't base its decision to pursue an appeal solely on the likelihood of winning a single case, or how rational the case is. The outcome of the lawsuit could set a precedent that other parties in the SEC's broader regulatory program will have to consider. Both the short-term effects of the court rulings and the long-term effects on their overall goal are taken into account. It was after the decision that Alderode made it clear on CNBC that the SEC had lost on every major point. He added that the SEC has 60 days to decide whether or not to file an appeal. This ruling could have consequences beyond Ripple, as it could lend credence to Coinbase's ongoing legal disputes with the SEC, as stated by Elias Stein, a senior litigation analyst at Bloomberg. According to Alderode, Ripple's court victory might have an effect on the cryptocurrency market. He is optimistic that the company will continue to grow despite the SEC's hostile attitude toward cryptocurrencies, which is taking focus away from their core competency. As the SEC's campaign on cryptocurrencies draws to a close, Ripple's triumph could impact regulatory relations with the industry. If the government is serious about encouraging the use of cryptocurrencies, according to Stuart Alderode, chief legal officer of the U.S. government's legal department, it should not appeal Judge Torres' partial ruling in favor of Ripple. The CCC has lost every major legal battle, including the one challenging XRP's status as a security, according to Alderode. Judge Torres delivered the decision in the 4-year legal battle between the SEC and Ripple on the most momentous day for the XRP community. After Hayek and Torres found proof that Ripple should have treated the XRP transaction with institutional investors as a security, the SEC fined the company $125 million. However, Ripple was upheld by the court. A legal officer from Ripple recently discussed the decision in an interview with CNBC. Alderode's Mackenzie Segallo. It was a major win for the business and the sector as a whole, according to him. Since the CEO's feud with the SEC endangered the future of the sector, Alderode was pleased with the agreement's terms. This occurred because following Gary Gensler's appointment as chairman, the SEC has been vocal in its rejection of Bitcoin. Ripple was initially sued by Gensler's predecessor, Jay Clayton, when Gensler claimed XRP is a token. According to Gensler, Ripple was completely defended when the SEC failed to classify XRP as a security token. Assets, whether physical like gold or digital like XRP, cannot be considered security in and of themselves, according to the court's decision on this matter, which Alderode raised. Conversely, a corporation might be subject to fines for violating securities laws if it packaged these assets as securities, incorporated the assistance of experienced outside parties into their packaging beginning in 2015. The Securities Act required their registration. This aspect of the judge's decision is something we really value. Torres granted Ripple 30 days to settle the fine, and Alderode assured the court that Ripple will adhere to the decision. In the end, Alderode believes the SEC will be able to put an end to the company's misery and turn its attention to other important matters. Further, in his opinion, this would be an opportunity for Vice President Joe Biden's administration to start utilizing blockchain technology and cryptocurrencies to boost the U.S. economy, which would be a significant change of direction. While Ripple is relieved that its 4-year legal battle with the U.S. Securities and Exchange Commission is finally over, some legal analysts still don't think. The company came out on top in the most recent court proceedings. A currency exchange network and the brain behind it, XRP, are known as Ripple. In the ongoing legal battle between Ripple and the SEC, was this the beginning or the end? On August 7th, the company announced that its 4-year legal battle with the SEC had come to an end. According to CEO Brad Garlinghouse, the court reduced the SEC's first punishment proposal by $94 million, from $2 billion. The outcome, according to Garlinghouse, was due in part to the law and the industry's performance. The community's reaction to Garlinghouse's publishing has caused the value of XRP to rise for 26 days in a row. A big win for their client, Ripple, the lawyers have said following the most recent court decision. In spite of this, not everyone is ready to call it a win. A few have even speculated that the court battle may have more chapters to come. Still, Ripple has doubts even. After coming out on top, it is still difficult to declare a winner in the case, according to an attorney with C. Clin and a former member of the SEC's counsel. The SEC lost its lawsuit when the judge reduced its desired seizure remedy from $2 billion to $125 million, but this is still happening. Despite the fact that there is still a lot of gray area in the law when it comes to how security regulations should be applied to cryptocurrencies, and the fact that the company's operations have been disrupted since the case began in late 2020, Mustache asserts that Ripple has won. I don't think it's worth it to spend years in court fighting over a case that will never be resolved just to lose a token or asset, have it removed from exchanges, fight authorities, and pay a hefty fine. And story from the Legal News Service's 360 edition triggered this warning: the already astronomical price tag that would accompany a victory for Ripple would increase if the CC decides to contest any parts of the case. October 1st is the cutoff date for the CC2 to submit their appeal. Within 60 days following the date of the most recent ruling, the SEC must comply in order for the court to make a final determination in the Ripple case. An advocate for XRP in the legal field can choose to do the same. As of today, August 7th, the 60-day countdown to the appeal deadline began, as announced by Fred Rispoli. Eleanor Terrett, a reporter for Fox Business, argues in an article that the SEC is more likely to rely on previous court decisions than on the most current remedial verdict. The ripple effect of XRP's price changes is not the reason the cryptocurrency is making news at the moment. The most significant change in its recent past is actually the cause of this.